So now we'll start with our last presentation for today. Donald Taylor. I would like to present you Donald. Is the copyright officer at the head of the library, interlibrary loan, Simon Fraser University in Burnaby, British Columbia, Canada. He is a member of the IFLA DDRS Standing Committee. Donald also serves on the Canadian Federation of Library Associations Copyright Committee, which works to promote copyright knowledge in libraries and works to bring the voice of libraries and librarians to public policy discussions on copyright. He has always been fascinated by the integrity of the international resource sharing system and hopes that in digital world where many rights holders seek to limit resource sharing, that librarians, publishers, and policy makers can work together to ensure that resource sharing is allowed to flourish.
Thanks, Katya. And unlike Ibrahim, I'm just going to stand in one place. And so, so today is just going to be a brief overview of copyright, and then we'll also look at licensing as well and how the two interact. So, what is copyright? Copyright protects the things you see on the screen. Literary works, dramatic works, musical works, art, all sorts of things you could think of, as well as a performance like me talking in front of you right now. Your child doing a dance routine. Okay, those are all protected by copyright. Copyright obviously refers to the right to copy a work. That's where the term comes from, but it also includes other rights like the right to broadcast, the right to translate a work. Okay, think of that the next time you're using Google Translate to translate entire documents. It includes the right to publish, to exhibit, or also to adapt. Okay, so if you want to alter something, that engages with copyright. And all of these things are going to be in your National Copyright Act. The copyright owner is usually the creator of a work, so the author, the composer, but the artist. But of course, as we learned in our previous session, copyright can be transferred. Oftentimes it's transferred to a publisher in the case of publishing. If you happen to be a musical act, often you'll transfer your copyright to the recording company, all those things. So in many cases in commercial publishing, especially, it is the publisher and not the author who owns the copyright. And finally, I think as Ibrahim touched upon earlier, copyright is effective immediately and automatically when a work is created. Okay, you don't have to do anything special to get it protected by copyright. The length of copyright protection depends on the country in which you are using the work in. Okay, the minimum is 50 years after the death of the creator, but it ranges from 50 years to 70 years, and in some countries it is 100 years. And of course, copyright is not eternal. It does expire, and when it expires, that means that you may use that work in any way, shape, or form that you want. Okay, an important aspect about copyright, I mentioned earlier, go read your National Copyright Act. That's because copyright is national. Okay, there's no giant, international copyright act that we all follow. There might be treaties, but the acts are all domestic in origin. So if you are in Qatar and you are copying something, and the author, for example, happens to come from Tanzania, you're going to use Qatar's copyright law because you are copying here. Okay, doesn't matter where the author is from, doesn't matter where the publisher is from, you follow the Copyright Act of the country that you're using the work in. Okay, and we actually do this because of the Berne Convention. And a core concept of the Berne Convention is national treatment, where everybody that is signed on to that convention, like Qatar, agrees to treat a Canadian the same way as they treat a citizen of Qatar. So that's called national treatment. Ibrahim also touched upon this, the function of copyright. Copyright's there so that we can create works, enable others to benefit from them economically and socially, and it also serves a public interest. which means that it allows for limited uses of works without obtaining permission from the copyright holder. And ideally, this encourages further research and further creativity because we're able to use other works that are still protected by copyright. And of course, part of that public interest is libraries. Libraries serve a deep public interest, and resource sharing is part of that public interest. And copyright allows libraries to engage in resource sharing. Just a quick note, by the way, on the public domain before I go any farther. So I talked about when copyright expires. When copyright expires, we say, oh, it's entered the public domain. Many people have this idea of the public domain as being anything that is available publicly. That's one definition, but when copyright, the public domain simply means works where copyright has expired or works that were never protected by copyright in the first place. So again, not everything is protected by copyright. Some things aren't. They just exist. Things such as data. The temperature yesterday in Doha, that's just a fact. Okay, so the government of Qatar can't copyright weather temperatures, for example. So things like that, simple expressions of data, distances, weights, all those sorts of things, they just are facts. They're not protected by copyright. And in many countries, government documents or else legislation or court decisions are also released into the public domain and are not protected by copyright. So again, copyright's national, public domain varies by country. So whichever country it is you're working in, make sure you know what's considered to be in the public domain in that country. Because again, when it comes to resource sharing, you can share that with anybody you want without even thinking about copyright. And since we're talking about resource sharing and copyright, the two, they're important to, well, copyright is important to resource sharing. That's because a lot of resource sharing requires making copies. You make a copy of something, you are engaging with copyright. And especially in today's digital environment, many publishers that we all know about, in their licenses, they will try to restrict interlibrary loan or document delivery. So it's important, you know, for librarians with resource sharing responsibilities to be familiar with the aspects of copyright that are applicable to resources, well, to e-resources, and to resource sharing in particular, and also to understand like the subtle differences between licenses and copyright law, because they're not the same. I'm going to take a very brief detour into the history of copyright, so I'm going to condense 300 years into one slide. The first modern Copyright Act was enacted in England in 1710, and it came with a copyright term of 28 years after publication. Okay, so copyright has extended significantly since that time. But again, going back to this national treatment, up until the 1880s, countries really gave no thought to copyrighted works from another country. There was like, they were free to do whatever you wanted with. Okay, if you were in France and you were using a work from Great Britain, yeah, I just did whatever you wished to do with it. But then along came the Berne Convention, and it instituted that core principle of national treatment, which is what we all follow today. Again, you treat the citizens of another country the same as your own citizens when it comes to copyright. And almost all countries in the world have signed on to the Berne Convention. And just as a little bit of interest here, the Berne Convention is also incorporated into major trade treaties now as well, because there's a WIPO treaty called TRIPS, T-R-I-P-S, and it incorporates the Berne Convention. So much money, much copyright now internationally is actually negotiated through trade treaties and not through a separate copyright treaty. General protection for copyrighted works, as I said, it's national, so the length of protection differs by country. But also, a work has to be copyrightable. What makes something copyrightable? Again, it varies a little bit country by country, but the key things are, it has to be marginally creative at least, okay? And there has to be a little bit of originality to it. It doesn't have to be like completely original or super creative, but just a little tiny bit. The bar is set very low, but the bar exists. Also, to be protected by copyright, something has to be in a copyright doesn't protect thoughts and ideas. Okay, so if you have the greatest idea for a novel and you go tell your friend and your friend writes it and publishes it, too bad for you. You shouldn't have told them your idea, okay, because your idea is not copyright protected. Only the novel is. And as I said, not everything is copyrightable, so data and facts, like we discussed earlier, not protected by copyright. And finally, remember, copyright's automatic. You don't need to register it. It just happens automatically. If your country does have registration, a way to register it, that can be handy if you want to prove that you own copyright, but there's no need to. As I said, there's exceptions to copyright. You can copy things without asking permission. That New Zealand video about Creative Commons was a little bit off on that aspect, because you can copy things without getting permission from the copyright holder. There's going to be exceptions that are specific to some groups, such as educational institutions, or to libraries, or to broadcasters, and especially to individuals. But along with these sort of separate group-focused exceptions, every country's Copyright Act is going to have a general exception. In places like India and Kenya and the United Kingdom, it's called fair dealing. In the United States and other countries, it's called fair use. Yet in other countries, it's called like a quotation rate or the right of quotation. Okay, and what that allows you to do is it allows you to copy a small, an amount of a work without asking permission. And there's all sorts of guidelines around that. As well, and this is relatively recent, there's the Marrakesh Treaty, which is the copyright for people with perceptual disabilities. So it's a special exception for people with perceptual disabilities. Many countries have incorporated into their national copyright acts, and it's really important for libraries because it allows us to share our collections internationally with individuals with print disabilities, so perceptually disabled, blind, or other visual impairments. And interestingly enough, this was the first international copyright treaty that was about an exception and not about increasing creators' rights, but instead giving rights to users. So, copyright and resource sharing. Lending physical materials does not normally engage with copyright. And again, that's because of a legal concept called exhaustion, which means that once you buy something, the copyright holder relinquishes, they can't control the subsequent distribution of it. Right? So a library buys a physical book, that library is free to loan that book to whomever they please, whether that's their local patron or whether that's a patron 6,000 kilometers away in another country. So if a library owns a book, loan it to whomever you want. Or same with a DVD or an LP. But like I said before, you make a copy of something, you engage with copyright. So sending a copy to another library engages copyright law. So you're going to want to make use of a copyright exception when you do this. So oftentimes you can use your general copyright exception, or perhaps your country might have a specific provision that enables document delivery, for example. Okay. So again, this is important. Why it's important for people working in resource sharing to be knowledgeable about their country's copyright law, because you're going to want to know what is that copyright exception that I can apply to send a document from Kenya to Tanzania. So how do you apply that general exception? There are some rough and ready guidelines. Again, these are just guidelines. I don't know the intricacies of everyone's National Copyright Act, but things to be aware of. The copying should be for a non-commercial purpose, such as education or research. That's always an important thing. The amount copied should be minimal. It's like one chapter, one article. Not all the time, but you can be pretty sure that in almost all cases, if you've copied that entire book and send it, that's going to be copyright infringement. Also, consider the type of work that you are copying or being asked to copy. It's going to be more fair, as they say, to copy a research article or to copy a chapter from a scholarly monograph than it is to, copy a short story from the latest short story compilation of a famous novelist, for example. Okay, so, and also you need to consider, like, although it's very hard to know, is there going to be any economic impact from this? Like, is your copying going to lead to a reduction in sales of a work? Likely never, but it's just something to bear in mind. So libraries should have responsibilities when they work with copies. Obviously, you're going to want to abide by the copyright exceptions established in your local law. You're going to want to follow your library community's best practices when placing and fulfilling article requests. You're going to want to include a statement that says the material should be used for educational, research, or personal purposes. So letting the recipient know this is how it can be used, and also letting the library that requests the article how it should be used. You're going to want to deliver copies in a way that limits further distribution. So whether that is like you get many articles you'll get from European countries, particularly from Germany and parts of Switzerland, you have to print it off. Okay, you can't even download the digital file. So that's one way of protecting further distribution. Okay, so just some way of protecting it. Don't just email it to the other library, hoping that it never gets distributed farther. Also, as Ibrahim mentioned, you don't want to use shadow libraries. You don't want to be going to Sci-Hub to fill interlibrary loan requests, because again, that puts your library in a legally compromised situation because you're engaging in copyright infringement. And lastly, although it's very tempting, you should not be storing copies that you've already sent in order to just reuse that copy again the next time someone requests it. You copy something, you send it off, and you destroy the copy. And if someone needs it again next year, you just make a new copy. So I'm going to move into licensing here. You all know about licensing. It's been around for decades. And in today, lots of libraries are paying more for digital content than they pay for their physical content. But again, unlike physical materials, licensing means you are leasing or renting the content. Okay, it's licensed in some way. You don't just own it outright. Whereas under physical content, it's owned and it's governed by copyright law. Commercial digital content is, in most cases, governed by a license of some kind. And there's usually going to be a different license for each resource. So instead of, you got the one copyright law for your entire physical collection, and then you got your digital resources with 100, 200 different licenses governing them. And last thing to bear in mind is that, resource sharing is traditionally based upon libraries owning an item. So licensing changes things up a little bit. A license may allow for perpetual use and perpetual access, but it still doesn't mean that the library owns it. And licensing, of course, governs things such as sharing it via resource sharing, how patrons can use a resource, how the resource can be accessed. Is it only on campus? Is it off campus? Is it only on this one computer terminal? And also it's about, where the resource can be accessed. And remember, we've been using e-resources for 30 years and more, but still many library patrons, well, especially the younger ones, they never knew any better, but even especially library employees too, they don't know that there's a difference between that electronic resource and that physical resource. They think their uses are governed by the same, but they're not. So what's a license? A license is just another name for a contract. It's going to be between the library and the vendor or the publisher. What a license does allow is it does allow the copyright holder to control, to a much greater degree than with physical items, how the work is going to be used. So it allows the copyright holder to go around copyright law and license things that are in a more restrictive way, usually, than copyright law would allow for. Also, it allows them to implement things that are called technological protection measures. So such as you can only print 5 pages, or you can't print it at all. You can just read it on your screen. All of those things, they're technological protection measures, and most people's copyright acts, because of the trade treaties they have signed, will not allow you to circumvent that technological protection measure, even if it's for an allowable purpose. So, unfortunately, library licenses can sometimes be contracts where the library agrees to not take advantage of copyright exceptions. So, what are the terms of a contract or license? Licenses or contracts are only valid when both parties agree to them. Okay, so a fundamental aspect is the ability to negotiate. So you always want to try to negotiate. And it's important for librarians to try and negotiate better terms around resource sharing when they sign agreements. Sometimes the negotiators on the part of a library don't even think about resource sharing. So it's incumbent upon resource sharing librarians and others working in resource sharing departments to let negotiations, the people who negotiate these contracts, know the resource sharing is important and they need to try to encourage or ensure that there's some resource sharing allowed in the licenses they sign. And of course, that's easier to do when it's a consortia, a group of libraries negotiating, rather than a single library negotiating on its own. You might be wondering who's bound by a license. Okay, so again, this presentation is not legal advice, but licenses are binding between the parties that signed them. Okay, so remember that. If my library signs a contract with, say, Elsevier, Simon Fraser University and Elsevier were the two parties to the contract. Members of the university community are bound by it. But if I turn around and send that article from an Elsevier journal to a library in India, okay, the user in India is not bound by the contract between Elsevier and SFU. They're simply bound by India's Copyright Act. So they just need to use their Copyright Act for that article because the license doesn't bind them. It can't. Okay, they're not a party to it at all. Okay, unless we make them agree to something when we send them the article. So just remember that. So the library to whom you send a copy is normally just going to have to apply their copyright legislation, not the terms of your license. Many countries, IFLA and other national library organizations recommend that nations implement what's called contract override legislation. Some countries have it. The United Kingdom has it, Singapore has it, Ireland has it, along with a few others. IFLA has a nice document on it. You're all going to get these slides, so you'll be able to go to this URL and see like every country listed, and IFLA tries to describe like what are the, if there are any contract override provisions in their Copyright Act, and if so, what does it allow? Also, don't forget too that some non-copyright elements of a license might be nullified by your country's own legislation. Okay, like if you look at some licenses, they might give you a list of countries that you can't send to, for example. And you should probably ask your legal counsel, like, does our law allow that? Is that even legal under our country's laws? Okay, some of those things like that. So again, if you have those kind of questions, just take them to your local lawyer at your institution. And the answer to that question is yes. Licenses can override copyright legislation. You go to any lawyer and they are going to say, yep. Okay, so a license, private law, and it trumps the public law of copyright. I mean, some people might say, oh, well, you never know, it depends. But those are just legal scholars writing legal articles. So without clear legal guidance to the contrary. So unless you've got a court case in your hand that says something different, or your government legislation says something different, always go on the assumption that the license is going to override anything in your Copyright Act. And finally, license or contract enforcement. Both parties, of course, can cancel or suspend a license if the other party has breached it, okay, if they don't fulfill their obligations and responsibilities. And, the most obvious one of that, which I'm sure many of you have seen in your own library, is someone accidentally downloads too many articles or too many abstracts too fast, and the provider cuts off access until you promise to remedy the situation. Okay, but the vendor can halt the license for other infractions as well, including if they think there's some you know, copyright infringements happening in the interlibrary loans department. Okay, so again, both sides, they can enforce a license. And that is the end, except for your question, which is on your sheet. And let me just... it's right here, right?
No, no.
Oh.
It's not needed.
What do I have?
It's already here.
Oh, awesome.
You're welcome. Here is your presentation. Here are the results.
Thanks.
For the word cloud, just press this one.
Thank you. Oh. Excellent. So there we go. My work is finished. You're all getting the question correct. Most of you are. So, oh, hang on. Yes. Where'd the mouse go?
Stop here.
I can't.
Oh. Where is the mouse?
Where's the mouse?
There is something wrong. Okay. Oh, something here. No. No. We cannot.
Yeah.
We cannot find the cursor.
Sorry. Technical issue. The cursor disappeared. This isn't a touchscreen, is it?
Just to wrap it up
Yep.
about copyright. We are waiting now a very big event in copyright, which is Mickey Mouse will be in the public domain very soon. And the story of Mickey Mouse is very interesting because the laws in the United States was that the copyright protection is for 50 years after the death of the author.
Let me do it.
And Mickey Mouse was approaching to be in the public domain. So Disney, they had pressure on the Congress, so they passed a law to extend the protection to till 70 years after the death of the author. And now the 70 years is going to end very soon, next year, I guess, or the year after. So we are waiting to see what Disney will do to extend the protection for Mickey Mouse.
You can use the other mic.
But there's a case with Sherlock Holmes, right? So basically, they can give Mickey Mouse a new character. Basically, characters in U.S. law are protected as well. So they can give Mickey Mouse new features or new character features, and they can extend the copyright. But sneaky.
Yes, exactly. And Disney are very great at protecting their rights. I can give you an example. Pinocchio, the story of Pinocchio is in the public domain. And another company, they made a movie of Pinocchio. Then Disney sued the company. They said that you are imitating our movie, Pinocchio. But the company said that Pinocchio is in the public domain. So the claim of Disney is that the character you draw for Pinocchio is inspired from our movie. So the story is in the public domain, but the drawing of Pinocchio is not in the public domain. So this is the case of Disney because it's very interesting. They protect their rights very well. So we are waiting if they win or the public domain will win in the case of Mickey Mouse. And now we got the results. You got entertained.
No.
That first question.
Try to help you one more time.
Sure.
Okay. There's something wrong.
What happened here?
First, yes.
Any questions, by the way, while we're waiting? Yes.
Especially the national case.
Here it is.
Provider, I will follow
Just press this one.
law. But as a borrower, if I provide something to my patron, let's say I'm getting a full text copy of an entire book, which says from a country in which only 50 years is copyright term. Meanwhile, I'm living in a country with a 75 years of copyright term. So if I receive the entire book from a shorter term country, can I pick this entire book to my page? No, right?
No, no. Actually, we run into that problem. I live in Canada, where for the next 3 months, the copyright term is life plus 50. So routinely, you know, a US library will ask us for something and we're like, it's in the public domain. And of course, no, because it's got an extra 15 years still in the United States. So we're not able to send it to them as a full text book, for example. Right, so yes, no, that's a great example of actually why you have to be aware of your national copyright laws, no matter what the lending library happens to send to you. Okay, so there we go. Great feedback. The majority got it correct. You just follow your local copyright law. And then how do I see the, oh, hang on. Yep. So let's see if there's any word cloud items. Yes. Oh, Disney, I like that. And you know, by the way, just so let's not pick on the Americans here, because it's not just the United States that does things like this. Even in Canada, you may never have heard of this, but I've forgotten the character now. Very famous. She was a little orphan girl, grew up in Prince Edward Island. Help me. Anne of Green Gables. Thank you so very much. So Canada actually made changes to the copyright legislation surrounding like unpublished manuscripts in order to protect, you know, the estate that held the Anne of Green Gables copyright for a little bit longer. All right, anyways, thank you also very much for your attention this afternoon, and for the last session of the day, listening to someone talk about copyright, that shows commitment on your part. So thank you.